Next, I want to move on to common law claims. There are, notwithstanding the UCC, there are, under Florida law, implied warranty claims that are available at common law, and those are implied warranties of merchantability and fitness that apply to the sale of new homes and condominiums. Seminal case of Gables v. Silver here in Florida, Florida 4th DCA case that came out in 1972, applied those implied warranties to the sale of new homes and condominiums, and that was sort of the exception to the concept we all learned in law school of caveat emptor, which is, buyer beware. And a quote from the case: with Gable, Florida joined a rapidly growing minority of states, which has recognized it as an exception to the general rule of caveat emptor in sales of real estate, an implied warranty of habitability or merchantability in the sale of new residence. And that's a Conklin case, which is a Florida Supreme Court case in 1983 that cited back to Gable and recognized that implied warranty exists at common law. However, in Conklin, the court declined to extend that implied warranty that's created in Gable v. Silver to the purchase of an empty lot that contained a defective seawall. So in that case, the court said, no, we're not going to extend that to a defective seawall. Under the common law implied warranty, a developer can be held liable for its breach if it fails to construct according to the plans or specifications. I said plans in the outline, but as most of you I'm sure know, there's always specifications that are part of a construction project. And so I really use those words synonymously. If a developer or contractor does not build according to the plans or specifications, and that could be deemed a breach of the implied warranty, or fails to build in a workmanlike or acceptable manner, or again fails to provide a unit or building which is reasonably habitable, and that's the Schmeck versus Oates Condominium Association case cited in materials. Failure to comply with specifications is a breach of implied warranty of fitness under the David v. B&J Holdings Corp case. And these implied warranties at common law run in favor of condominium association and first purchasers of units. Now, contrast that to the implied warranties that we talked about in the Condominium Act. Those are in favor of not only the initial purchasers but subsequent purchasers. But these implied warranties at common law only run in favor of the first purchasers who buy directly from the developer. Recently, the legislature, in direct response to the Lakeview Reserve Homeowner versus Miranda Homes case, abrogated that case. The 5th DCA in 2010 extended the implied warranty of habitability for a builder, the obligations of fitness for a particular purpose and merchantability to private roads, drainage systems, and retention ponds and underground pipes that immediately supported the residential subdivision. So here the court said we're not only going to extend this implied warranty of common law to the building itself. This was a residential subdivision, and the court reasoned that really in order for this residential subdivision to be habitable, the roads, drainage systems, retention ponds, etc., that supported that community, there were defects in that, and the court extended that. And the folks up in Tallahassee did not, or I should say the lobbyists, did not like that, the ones representing developers, and lobbied the folks in Tallahassee. And they actually amended 553 to create a new section, 553.835, that expressly overruled that case. So if you don't like what the courts say, you go to your legislature and you simply have them abrogate the case by statute. So Miranda Homes was short-lived here in Florida. Next, I want to talk about the Spearin Doctrine. which comes from a very old United States Supreme Court case. And Florida, I'm sure a lot of jurisdictions apply it. Florida does apply the doctrine, and it's really referred to as the doctrine of constructability, and that's because the owner, most of the time, if you're dealing in traditional construction projects, they hire the design professional, the architect or the engineer, who creates the plans and specifications, and then the contractor builds. Now, of course, if you've got a design-build project and the owner is hiring a contractor that is going to then design and build a project, and that is, permissible here in Florida. You can't have a contractor, that provides both design and build services as long as the contractor hires a licensed architect or engineer as a subcontractor to design the project. So if it's design-build, no Spear and doctrine because the owner is hiring the contractor to perform design function. But in your traditional project where the owner hires the design professional who creates the plans and specifications, the owner, and this is the Spearing case, and now it's known as the Spearing doctrine, impliedly warrants to the contractor that if the contractor follows the plans and specifications, that the contractor will be able to build, that which the owner wants him to build, that those plans and specifications are suitable for construction. And where the owner breaches that implied warranty, the contractor can recover unanticipated construction costs incurred due to a latent defect in the project plans and specifications. That's important when you talk about, well, is it latent or is it patent or patent? Tomato, whatever you prefer. If it's a latent defect, and it doesn't just jump out at the contractor, it's really not a defect that the contractor, although they're familiar with plans and specifications, they're not designers, and I don't think we hold them to that standard here in Florida. We don't hold them to the same standard as a design professional. And so if there's a latent or hidden defect in the plans and specifications and the contractor has no idea at the time that they bid the project and they're involved in construction and now a defect comes to light in the design and now the contractor either has to do additional work or may incur additional construction costs that were not foreseen. And so clearly they could not have factored that into their bid price. And under the Phillips and Jordan case that I've cited in the materials, where the owner breaches its implied warranty under the Spear and doctrine, the contractor is able to recover those additional costs. Now, for a public owner, if you're dealing with public works contracts, which I do quite a bit of, my firm represents a lot of municipalities here in Florida, and a lot of times I get involved representing our cities with public construction projects. And when you're dealing with those, the contractor has to show that it relied on an alleged defect or misrepresentation made by the owner, and that its reliance was reasonable. And I think that gets back to this issue of in the Phillips case, whether the defect was latent or patent or open and obvious. If the contractor is aware of the defect in the plans or specifications or error or omission, I don't think that they can reasonably rely upon it and then at the end of the job say, there was clearly a defect in the plans and now I'm entitled to recover, my additional cost. Reliance has to be reasonable. And here in this case, this is the Martin K. EB construction case that I've cited. Reliance is not considered reasonable if the alleged defect or misrepresentation was an obvious omission, inconsistency, or discrepancy of significance, or if the contractor knew about the defect during the bidding process and basically said nothing about it to the owner. And so you can't sit on your hands knowing about the defect and then come back after the fact and try to claim the additional cost of the contract. But again, if it is a latent defect and you didn't know and reasonably could not have known about the error or defect in the design, then you may be able to recover for the breach. Another case that I want to talk about in the materials is Miami-Dade Water and Sewer Authority versus Inman, and there the bid documents actually had a disclaimer by the public contracting entity, and basically the court found that negated liability by the contracting authority for the extra costs incurred as a result of errors in the drawings. So I guess the moral of the story is there that the owner is coming right out and saying, yeah, our design team, our architect or engineer may have errors in the drawings, but there was an express disclaimer right in there, and the court there, and of course that's the 3rd District Court of Appeal in Florida here in Miami, that's the appellate court that oversees Miami, found that that disclaimer was enforceable. And there the contractor could not recover the additional costs. Okay, another theory in Florida, common law claim, and this is in tort, strict liability in tort, and this does not deal with just economic damages. You're not going to be in strict liability, but if there's a construction defect that results to damage to other property or personal injury, then strict liability may provide a remedy to go after a manufacturer. And under this doctrine in Florida, which was announced in West versus Caterpillar Tractor, which I've cited in the materials, holds a manufacturer liable in torts where it places an unreasonably dangerous product on the market. And I guess in the context of construction defects, this would be building material that ultimately winds up into the finished project. Knowing that it will be used without inspection for defects, I mean, obviously a buyer of a home is not going to inspect these things. So I think we can assume that the buyer is not going to conduct an inspection, and the defect causes personal injury or property damage. And so West versus Caterpillar allows strict liability and tort against the manufacturer. And essentially when our Florida Supreme Court came out and announced that doctrine, it basically supplanted all non-privity breach of contract claims against manufacturers. And we're going to talk a little bit more about that later in the materials, but in the absence of privity, I mean, unless you have an express warranty that you're invoking against a manufacturer, in the absence of privity of contract, you are not going to be able to bring a breach of warranty, like an implied warranty claim, against a manufacturer. And if you're dealing with, like I said, just economic loss, you're not going to be able to go after that manufacturer in tort. And in fact, the West Caterpillar case, in announcing the strict liability, basically did away with all non-privity breach of warranty claims against manufacturers. So, again, if a manufacturer puts a product on the market that is unreasonably dangerous and it ultimately, and it's not going to be inspected by the ultimate consumer, and it causes property damage or personal injury, you may have a cause of action against them for strict liability and tort. An exception to that, which is found in the Juno Industries case, which I cited, is a manufacturer is not liable to a purchaser where the purchaser is actually going to perform, is going to inspect the product and perform tests to basically find out if the very defect that they're looking for exists. And so the presumption being that if a manufacturer has inspected a product and put it on the market, it should be liable in tort if it ultimately proves to be a defective product. But here, where the purchaser is actually going to perform those tests, and during those tests, the defect arises and causes injury, the court in Juno said, no, we're not going to hold the manufacturer liable, strictly liable in tort for that. However, general negligence principles still apply. So if there's some independent basis to sue the manufacturer in negligence, and that remains to be seen given the status of our economic loss rule here in Florida, which I'll talk about a little bit later. So if there is a viable cause of action for negligence and the manufacturer is independently negligent, then you may have a cause of action against them for negligence. But they will not be held strictly liable in tort where the ultimate purchaser is going to conduct those tests. Looks like we've got about 12 minutes left to our break, and so we're going to keep going here. And if I get to a natural breaking point right before that, then I'll let you know. We can take a break. Otherwise, I may run over a little bit, and then we'll take a break shortly after that. Okay, and the doctrine of strict liability in tort applies to defects not only in manufacturing, so the actual manufacturing process, but also in the design of product. Products must be used for their intended purposes. If the ultimate user does not use it for intended purposes, then the doctrine of strict liability in tort will not apply. And that was recognized in the Westinghouse Electrical Corp case. And in that case, the manufacturer of electrical transformers was not subject to strict liability for injuries that occurred during the dismantling of the transformers. Hello, I'm talking about electrical transformers. And the court said that there was a substantial alteration of the product at the time of exposure during the dismantling. And that was not the intended use. So in that case, the doctrine did not apply because the product was not used for its intended purposes. So that is a defense that a manufacturer can raise. And it's worth noting, at least in construction defect claims, that the doctrine may, and I say may, not apply to contractors improving real property. And I've cited some cases there. The first one dealt with the defective sewage treatment plant. That was a Newman case. A sealer on a private road, repaving of public roads. In those cases, the court found that the contractor, that the doctrine did not apply to the contractor. However, the doctrine may apply to a contractor where there's a high degree of risk involved. And the Hutchinson case dealt with pile driving, and the Morse-Henry case that I cited dealt with blasting. So possibly you may have that remedy available, but most of the time you won't have that remedy available against a contractor. And again, you will only have that remedy available against a manufacturer where there's personal injury or damage to property other than the defective construction. Okay, another common law cause of action is your garden variety negligence claim. And unlike strict liability, see, in strict liability claims, you don't have to prove negligence. Under that doctrine we just talked about, the manufacturer can be held liable, strictly liable in tort, even if they're not negligent. So unlike that doctrine, negligence arises where obviously somebody owes a duty of care to an individual, and they breach that duty of care, and then there's resulting damages. And that generally requires personal injury or property damage. You know, here in Florida, for years, you would often see that litigants would throw in a breach of, in addition to their breach of contract claim or other remedy that they might pursue, they would throw in a negligence claim. You'd see that all the time. And for years, those got knocked out because of the economic loss rule. And I'm going to come back to that again later on in the materials. And that deals with, again, just economic loss where you don't have personal injury or property damage to other property. And you see that phrase used throughout the case law. But where you do have personal injury or other property damage, regardless of contract, regardless of any other remedy, if you've got a defect that causes property damage or personal injury, you have a cause of action and negligence against the contractor or subcontractor that furnished the defective construction. And you also can pursue a negligence claim against a design professional for purely economic losses, even in the absence of privity, and that's under the Hewitt-Keir construction case that I've cited. And before that case, we had a case here in Florida, which a lot of you may or may not be familiar with, which is a Florida Supreme Court case, 1973, A.R. Moyer, Inc. versus Graham. And in that case, there was an architect that was, was performing contract administration duties, that had a supervisory role in the case. And because the architect was so involved in supervising the contractor's work, and the contractor in that case suffered economic damages because of defective plans and specifications, there were delays in correcting defects in the plans, delay in issuing final acceptance by the architect, and negligent supervision. The court in A.R. Moyer limited the case to those facts, but said that the contractor could recover against this architect for those economic losses, even though it had no contractual privity. Now, in the Hewitt-Keir case, the court found, by the way, in the A.R. Moyer case, the court found there was a, quote, special relationship between the architect and the general contractor. And in the Hewitt-Keir construction case, the court found that special relationship even where the architect did not have supervisory responsibilities unlike in the A.R. Moyer case. And in the Hewitt-Keir case, the contractor relied upon erroneous design documents. So, the theory being the architect really knows who is going to be ultimately using these plans. I mean, obviously, the architect or engineer or design professional is working directly for the owner, but let's face it, they know the contractor is going to be building off these set of plans and specifications, is going to be relying upon them. And in this case, the court found that purely economic losses were recoverable, even though there was not this supervisory role or special relationship. Under Florida cases, you cannot sue a manufacturer for negligence, and that's the GAF Corp versus Zach Construction case, which was a third DCA case. And I got to tell you, I have dealt with that case. I think it's a horrible case. When I'm representing roofing clients who want to go after a manufacturer for a defective product, and of course, the first line of defense for manufacturers always say it's not our product. Now, I guess I sound a little jaded because I typically am representing the contractor, not the manufacturer. But they always say it's the contractor's work. But when there is a defect, under the GAF case, the case says that you can't just sue the manufacturer for negligence because you don't have contractual privity. Now, if there's an express warranty and you're the beneficiary of that warranty, sure, you can invoke an express warranty claim, but you can't sue the manufacturer in tort, in negligence, simply to recover economic losses because of the absence of privity. Now, there are exceptions to that, and I've cited two cases. There are exceptions to that. In a typical scenario, you have a manufacturer, like I spoke about earlier, that will, we've got about 4 minutes left before a break. You've got a manufacturer that will, place its product in the stream of commerce that will go to some wholesaler or a retailer, but ultimately it winds up in the hands of a building supplier, and they ultimately will then sell direct to a subcontractor or a subcontractor or a contractor directly, and that's typically what happens. And the manufacturer has absolutely no dealing whatsoever with the ultimate purchaser of the product, or if you're dealing, let's say, with a roofing subcontractor who's installing a defective product, who has no direct communication or no relationship with the manufacturer, really that contractor is dealing directly with its supplier. Under the GF case, you can't sue the manufacturer for negligence. Now, where the manufacturer does have direct communication with the purchaser about the product, and Cedars did not deal with construction, but nonetheless, its rule of law would apply equally with construction. In that case, where you've got direct communication between the manufacturer and the ultimate purchaser, where the manufacturer is making representations about its product that leads the ultimate purchaser to purchase, and I'll liken this to a construction project. So you've got your contractor that's buying direct from a supplier, but the contractor had direct communications with the manufacturer, and the manufacturer, made direct representations that the contractor relied upon in purchasing from the purchaser. In that case, you're going to have the court's going to relax that strict application of the privity requirement, and you are going to be able to go after a manufacturer despite the lack of privity. Also, if you have an assignment, so if your supplier has an available express warranty or even an implied warranty claim against the manufacturer who it purchased from directly, because remember I told you have to have privity of contract to enforce an implied warranty claim here in Florida. So if a supplier is buying direct from a manufacturer, it, unless disclaimed by the manufacturer, it will have an implied warranty claim against that manufacturer. It likely will also have an express warranty claim by the manufacturer. And in the Ashley Square case, you actually saw where the supplier assigned all of its claims, and so you can invoke that assignment and you stand in the shoes of the supplier. So in that case, even though there was no direct privity with the manufacturer operating under the assignment of claims, that was found to be okay.